Good afternoon. Today on Report to Wyoming, we'll be taking an in-depth look at the battered women syndrome in Wyoming law. That's next on Report to Wyoming. We are joined today on Report to Wyoming by our legal team, Frank Chapman to my left and Dallas Laird to my right. Last week there was a case in the Douglas area when a woman was convicted of second-degree murder. Her defense attorneys in that case had raised the battered women syndrome as her defense, saying that she had been a long-time sufferer of spousal abuse from her dead husband. It did not work in that case, so we thought this would be an appropriate time to talk to our legal experts about exactly what is the battered women syndrome, and is it an effective way to defend a woman who has killed her husband in the state of Wyoming. Since it has been on the books, I don't believe it has been used successfully yet, has it?
Well, Frank used it successfully before it was on the books, so probably 20 years ago. I think the name was the Judy Austin case, and the lady shot the husband, I think shot him in the back, and the local Natrona County jury acquitted Miss Austin, and it was before the battered woman syndrome statute existed in Wyoming. The defense was known. Of course, the battered woman syndrome, I think, is something that is a little confusing. Under Wyoming law, what you really are showing is self-defense, and then it's tied in with what they call post-traumatic stress disorder, which is things that have happened to someone for so long. You know, you've heard about the Vietnam veterans. They hear a loud sound like a backfire of a car or something, and they think they're being attacked, and they shoot someone, and people find out that it's a very serious mental disease. And what happens with the battered woman syndrome is, after being battered and hammered and hurt and abused over a number of years, some women fall into the category of where they think that, you know, every time this person looks at them, they're about to be killed, and so they finally defend themselves, and rightfully so. And now it's time to go to court and show a jury that really were acting in self-defense, even though the person had done nothing to you at the present moment in time. But you can then bring into evidence what has happened over a course and a period to make you believe you had to defend yourself. Unfortunately, Ms. Trusky, the jury did not believe that. And it's been a very difficult defense in Wyoming. It hasn't worked in the past few years that I know of, other than this one case Frank tried 20 years ago.
Well, in 1978, I defended a woman named Judith Austin, as Dallas mentioned. And she was a battered woman. I was put in touch with a woman named Dr. Lenore Walker, who at that time was at Colorado Women's College. It's now Colorado College in Denver, and Dr. Walker was the national leading expert on what was then described as the battered woman syndrome. Dr. Walker came up with some of the criteria for the syndrome, and we had a very forward-thinking jurist here, a judge in Natrona County known as R.M. Forrester, who heard that case and allowed Dr. Walker to testify. And typically, what the post-traumatic stress does to battered women is that it teaches them what's called learned helplessness. Dr. Walker's research has shown that women who are battered go through cycles of battering, reconciliation, then there's a build-up toward a battering event, and then when they're battered again, they begin to learn this helplessness. And as a result of this learned helplessness, it results in loss of free will. Because of learned helplessness, typically a battered woman is unable to walk away from or escape a battering situation. Her ability to do so is impaired by this cycle of violence. And in 1978, we had the same basic self-defense law in Wyoming that we do today. The difference was that in 1978, Judge Forrester allowed Dr. Walker to testify. It was several years later in the case of Edith Burley, who was also in Natrona County, shot her husband under different circumstances. She was convicted. In that case, Dr. Walker wasn't allowed to testify, and the Wyoming Supreme Court said that the battered woman defense should not be used in Wyoming. It was nearly 10 years later when the legislature passed a statute describing battered woman syndrome and refers in that statute to the Diagnostic and Statistical Manual for Psychiatric Disorders, and refers criminal defense lawyers and prosecutors and judges to the American Psychiatric Association description of post-traumatic stress disorder, and that can now be used to show why a woman can't always escape a violent situation in a family. And it was very forward in 1978 for Judge Forrester to make those rulings, and I was very proud of that defense of Judith Ann Austin.
In the world of legal statutes and legalese, the battered women syndrome in Wyoming really is pretty short and sweet. It is only a 2-paragraph statute, but the thing is it does refer you to the other ways. How difficult is it as a defense attorney representing one of these cases to convince the jury that there is this feeling of helplessness, that this woman couldn't just wait until the battering spouse goes to work or goes wherever he goes and pack up the kids and leave?
Well, that's the biggest problem, Wes, is juries in Wyoming understanding what is really going on mentally with a person who has been for years severely beaten, abused, watched her children being beaten and sexually abused, and to understand what you just can't go out, ladies and gentlemen, and turn this guy in. Why do you live with him 20 years? And so these juries sit there and go, well, she could have just, done like you said. After he went to work, could have gone and turned him in, and everything would have been fine. Ladies and gentlemen, it just doesn't work that way. Any psychologist, any psychiatrist will tell you that people who have been abused and stomped on and made to feel worthless and no self-esteem for years are incapable of doing that. Finally, what happens is the anger, all of the trauma that's gone on over the years finally erupts like a volcano, and it's something that's uncontrollable. Wendy Trusky, in my opinion, wasn't guilty of second-degree murder. At most, any of these battered women syndrome cases, at most, it can't be anything more than manslaughter. It's an emotional killing, and people do this emotionally as a result of out of any premeditation or intent or anything of that nature. And I think, unfortunately, people in Wyoming are very conservative. They say, well, if it was me, I would have been a person who would have turned this person in. But you can't judge a case based upon what you would do. You have to judge the case upon what this person that you're judging did in fact do.
Are there prosecutors in the state that are sympathetic to the plight of battered women, or is this something where you are just looking at the black and white of, okay, here was a person who was alive, here is a person who is dead,
well,
someone has to be held responsible?
All of these cases are very unique. In other words, each of them has their own particular set of facts and circumstances that are going to be relied on by a prosecutor in making their decisions as to what to charge someone with and whether to go forward with prosecution. And a defense lawyer is also going to have to make some very unique decisions for each case. In many cases, the shooting goes on not during a battering incident, but well after the last battering incident. The battering may have gone on for 20 years, and suddenly the wife decides that she can't put up with it anymore and shoots the husband. Those are the cases where there have been convictions. So my advice here to women that are battered is, if you get yourself in that battering situation and you cannot get away, the self-defense arises only during a battering incident, not before and not after, but during the battering incident. It is then that a person in Wyoming is allowed to repel force with like force or equal force or greater force if used to protect themselves from death or serious bodily injury. And so it's not just a situation where in all instances women have fought back during a battering incident. In the Trusky instance, as I read in the paper, which I don't always believe, by the way, that battering had gone on for 20 years, but the shooting did not occur during a battering incident. It occurred instead at a time when Mr. Trusky had been doped up, made more susceptible to being shot, and it was done at a time apparently when he was asleep or not involved in the actual battering at the time. And
Well, there's some question about that, though, isn't there, Frank? Because she testified from the stand that it was going on during a battering, some of the other evidence and all. So that's something that nothing has been proven
Right.
completely one way or the other.
One of the jurors did comment, at least from what I read in the paper, that they just didn't believe her testimony with reference to some of those elements, which I don't know how well explained in her trial the post-traumatic stress disorder is. See, post-traumatic stress disorder, the theory behind it all is that these things have occurred so much that this gentleman who was killed, if he did something to her that was totally innocent in his mind, might make her think he was going to attack her and hurt her and harm her, and that therefore opens this whole flower of self-defense where she believes that he's attacking her. In her mind, she's believing he's attacking her, and then that gives her the right under Wyoming self-defense law to protect herself by any means necessary, even though what he did may not have been an attack on her. But just by virtue of his conduct, it triggers her mind to open up to all of these past abuses and believe I'm going to be abused again, and therefore I have to protect myself. That's the generalization behind post-traumatic stress disorder. It gets back to the loud noise and some person who has been in Vietnam, say, and who is subject to post-traumatic stress disorder, believing that I'm being attacked, and pulls out his gun, and really nothing has happened. But he's suffering from a mental illness because of very serious stress that happened in his life.
And this learned helplessness is a very complicated thing. It arises from socioeconomic, family, religious, and other backgrounds that people grow up learning. And in those circumstances, in many of these battering circumstances, women don't have the financial means, the emotional means to get away with their children, and to start a life of their own. And under those circumstances, in many instances, their only hope is to strike back.
We'll be back with more on the battered women's syndrome as a defense and as a phenomenon in Wyoming in just a moment. It would seem, I've covered a number of these trials that you gentlemen have worked on also, and it seems that there is a thread that runs through all of these, and that is a complete and total feeling of helplessness. The fact that you have absolutely no control over yourself and what is going to happen to you among these suspects who are actually the victims also.
Right.
Well, gratefully, the Wyoming State Legislature has been fairly forward-thinking in this instance, and they have created special statutes regarding assault and battery. And there's also a Domestic Violence Protection Act. It's known as the Family Violence Protection Act by the courts. And in those circumstances, people who are battered by a household member can go to court, get restraining orders. It's a violation of the law to not follow those restraining orders very carefully. People who are batterers can be taken out of the home situation for at least 90 days under these orders. And the legislature has tried to help, not only by passing those special statutes protecting family members, but by enacting this battered woman syndrome defense as part of a self-defense strategy for women who find themselves in this situation. Additionally, in most communities in Wyoming now, we have self-help centers which also have places where women can go with their children for protection. And I encourage people that are in battering or violent situations at home to reach out to the law enforcement agencies, to the social service agencies, and most importantly to these self-help centers to get protection, and do it now before the situation gets more violent.
You know, one of the things I think that the legislature could do, though, Frank, on this battered women syndrome is in a case like Miss Trusky, where she's now been convicted of second-degree murder, carries a minimum sentence of 20 years to life. Now, the truth of it is, if battered woman syndrome applied in her case, that should be something that should be taken into account for sentencing purposes.
Well, her lawyers raised the battered woman syndrome defense, and she was still convicted.
Well, I understand
and so
that,
under
but
those circumstances, the court's going to have to sentence her like it would any other second-degree murder. You know, there's cases
but my
in
point, though,
Massachusetts, for instance, where after this defense was finally recognized by the state of Massachusetts, the governor and the legislature there went in and released a vast array of prisoners who had been convicted for crimes much like Mrs. Trusky was convicted of. And you know, I think that the judge in Douglas, who's a very thoughtful man, will take into consideration what he learned about Mrs. Trusky and her situation in that home. Unfortunately, her and her children testified in this trial, and obviously the jury just didn't believe them.
well,
But there are no mitigating circumstances for second-degree conviction.
There
correct?
aren't. The only thing, the judge does have the power to do certain things, and in this particular case, though, in like all of Wyoming cases, the jurors do not know what the penalty is going to be. I know that there have been cases that are tried where jurors